Now, three events: the 1993 World Trade Center bombing, the anti-immigrant legislation in California's passage of Proposition 187 in 1994, and the 1995 Oklahoma City bombing prompted Congress to restructure United States immigration law in 1996. And the legislative changes were adopted in a rushed atmosphere under the Clinton administration. President Bill Clinton signed the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. So how do we try to pronounce that? Well, it's IRA. But anyway, it was an error. But nonetheless, it laid the groundwork for the massive deportation machine that exists today, where deportation is a constant and plausible threat to millions of immigrants. And as reported by Dara Lind in Vox, more people became eligible for deportation. Legal immigrants, including green card holders, can be deported if they're convicted of certain crimes, which cover a broad umbrella of offenses, some of which aren't violent. But in 1996, Congress radically expanded which crimes made an immigrant eligible for deportation. Now, previously, immediate deportation was triggered only for offenses that could lead to 5 years or more in jail. Now, under the Act, minor offenses such as shoplifting made individuals eligible for deportation. So when IRERA was passed in 1996, it was applied retroactively to all those convicted of deportable offenses. Dara Lind emphasizes that it got easier to deport people. Immigrants convicted of crimes weren't the only ones stripped of their ability to argue their case before a judge before getting deported. Anyone apprehended within 100 miles of the border. And the act required the government to hold more immigrants in detention before deporting them, thus making it substantially harder for them to get lawyers. And I might add, providing an incentive for the prison industry to cash in on the fate of undocumented workers. Deportees may be held in jail for months, even as much as 2 years, before being brought before an immigration board. Before being brought before an immigration board, at which defendants need to pay for their own legal representation. Let's listen to Don Kerwin of the Migration Policy Institute.
So what happened in the 1996 Immigration Act was the categories of crimes for which people had to be detained. The mandatory detention provisions were expanded quite significantly. And the effect of that has been that, in 1994, 1995, we were detaining about 5,000 to 6,000 people a night. And right now we're detaining 34,000 people a night. So that's expanded drastically. I mean, a couple of things have happened in the courts. One is that the mandatory detention provisions, while removal proceedings are pending, have not been found to be unconstitutional. In other words, it's constitutional, but for the short period or the brief period during which removal proceedings are pending. That's one decision. A second set of decisions, however, involves indefinite detention, and that relates to people who have already been ordered removed. And under two cases, the Zydvitas case in 2001 and the Clark versus Martinez case in 2005, the Supreme Court has held that you can't indefinitely detain somebody after they've been ordered removed from the country. In 6 months after they've been ordered removed, the presumption arises that that person ought to be released. Now that presumption can be rebutted, but basically that's the point at which the government seriously has to consider the merits of that case in releasing the person.